Why are employers uncertain about FMLA eligibility? Imagine running a busy workplace and trying to figure out if an employee qualifies for family and medical leave. It might seem straightforward, but many employers find it confusing. The Family and Medical Leave Act sets rules, but applying them in real life can be tricky. That's why employers often feel unsure about who is eligible for leave and when. First, not every employer is covered by the law. Only those with 50 or more employees within a 75-mile radius are required to follow FMLA rules. But figuring out if a business meets this size can be complicated. Some companies have multiple locations, and it's not always clear if they count as one or many. They have to look at shared management, control, and ownership to decide if they are an integrated employer. This can be a complex process, especially for companies with different subsidiaries or branches. Even if an employer is covered, they need to check if the employee qualifies. To do that, they look at how long the employee has worked and how many hours they have clocked. The law says the employee must have worked at least 12 months and completed at least 1,250 hours in the past year. Employers must track hours carefully, including overtime, but not paid time off or leave. Mistakes in counting hours or months can lead to wrong eligibility decisions. Timing also matters. Eligibility is based on the date the leave begins. If an employee becomes eligible during their leave, only the time after they meet the requirements is protected. This can cause confusion, especially if an employee requests leave just before they qualify. Employers need to know exactly when the employee hits the 12 months and 1,250 hours mark. The reason for the leave is another factor. FMLA only covers specific situations like having a baby, adopting a child, caring for a sick family member, or dealing with a serious health issue. Employers must interpret medical certifications and decide if the reason fits the law's definition of a serious health condition. Sometimes, understanding what qualifies can be confusing. State laws can add to the uncertainty. Some states, like California, allow employees to designate someone who isn't a traditional family member for certain types of leave. Employers must follow both federal and state rules, which can sometimes differ. Keeping track of these overlapping laws makes compliance more complicated. Practical challenges also play a role. Employers need to keep detailed records of hours worked, leave requests, and medical notes. Poor record keeping can lead to disputes or legal trouble. Clear communication with employees about their rights and responsibilities is vital. If employees don't understand the process, misunderstandings can happen, leading to claims of interference or retaliation. Handling intermittent leave, where employees take leave in small chunks, adds another layer of difficulty. Employers must track these absences carefully and ensure they are properly classified as FMLA leave. Managing this without disrupting business operations can be a real balancing act. Making mistakes can have serious consequences. Wrongly denying FMLA leave can lead to lawsuits. Giving leave to someone who isn't eligible can cause operational issues. This risk makes employers cautious and adds to their uncertainty. To reduce this confusion, employers should regularly review employee records, train their HR teams, and consult legal experts when needed. Using standard forms and staying updated on law changes can also help. Understanding these rules and having clear policies in place makes it easier to stay compliant and avoid mistakes. In the end, the detailed rules, overlapping laws, and record-keeping requirements all contribute to why employers often feel unsure about FMLA eligibility. By staying informed and organized, they can make better decisions and support their employees fairly.